What is the effect of the U.S. Supreme Court's decision granting U.S. presidents immunity? Join Richard Ebeling and me in this week's Libertarian Angle as we examine that question. Hi, I'm Jacob Hornberger, president of the Future of Freedom Foundation. Welcome to this week's Libertarian Angle, the show that brings you all the principled case for the libertarian philosophy. And I'm joined by my co-host, my good old friend, Richard Ebeling. Richard, good to see you again.
Good to see you, of course, and our viewers and listeners.
Yeah, thank you all for tuning in. Richard, we're going to talk about the imperial presidency today. The Supreme Court has solidified the concept of the emperor that we have here in the United States, holding in a major decision that the president of the United States is immune from criminal liability and presumably civil liability too, for all acts that he commits and is part of his official duties as president. And of course, this has stirred up all kinds of controversy, needless to say. What they're really saying is that no matter what the president does, let's say he goes and orders an assassination, as long as he can relate it to his official duties as president, can't go after the guy. And, this really doesn't surprise me, Richard, because, for many years I've been writing on the case in Chile of Salvador Allende. He was the democratically elected president of Chile. He had gotten a plurality of votes in 1970 in the presidential election. He didn't get a majority, so the election was thrown into the Congress, the hands of Congress there pursuant to their constitution. And there was a conspiracy here in the United States that consisted of the CIA and then other officials in Washington to prevent Allende from assuming office. And one part of that conspiracy involved payment of bribes to the members of the Congress. And the other one, there was like two tracks. The other track was a coup, a military coup that would take power and prevent Allende from taking office. And as part of this plan to get a coup, the CIA hired some thugs down in Chile, in Santiago, to kidnap the overall head of the Chilean armed forces. And this is a guy named Rene Schneider. And Schneider was a man of great integrity, and he was opposing this concept of a coup. Now, he was a conservative. Allende was like a socialist communist, but he had won fair and square this plurality of votes. And the tradition was that the Congress would go ahead and make him the president since he had won most of the votes. But the U.S. was trying to block it. And their second track, their alternative track, other than the bribery, was this idea of a coup. And Schneider was saying, no, our Constitution doesn't provide for a coup. And so we're going to go with the Constitution. That's my oath to support and defend the Constitution. You don't like this guy? Well, we'll just have to wait for the next election. Well, that wasn't good enough for the CIA and other U.S. officials. They felt that this was a threat to Chilean national security and also a threat to the U.S. national security. This guy was a socialist communist, Allende. This was the height of the Cold War. So they hired these thugs to kidnap Schneider on the streets of Santiago, and the kidnapping attempt took place. And Schneider, who was a military general, was armed and shot back at his proposed kidnappers, and they shot him dead. He later died in the hospital. So, and then the CIA was later caught trying to pay hush money to the thugs, trying to keep them quiet so that nobody would find out that the CIA was involved in this thing. And many years later, the Schneider sons filed a civil suit against the government. Kissinger, Henry Kissinger, I think other officials, I'm not sure. But it reaches the Court of Appeals, and they hold that the case is not valid. They're going to dismiss it on grounds of immunity. And they say, I'm not sure whether they used exactly the word immunity, but they said, this is a political question. We can't get involved with political questions. We lack the expertise to second guess the national security establishment. And when I talk about the national security establishment, I'm referring to the Pentagon, the CIA, and the NSA. This is the triumvirate of the national security state. And they said, look, when it comes to things like this, murder, which is what it was. Now, the CIA for a long time denied that they had planned to murder Schneider. I think is a lie, because what else could they have done with him? They couldn't exactly return him after kidnapping him. So my hunch is they would have had some of the thugs just kill him and then act shocked that this had happened. But nonetheless, under the law, there's a principle called a felony murder rule, that when you kill somebody or somebody gets killed in the course of a felony, you're responsible for that murder. And so they were clearly responsible for the murder, but the appellate court said no, that we're not going to second guess the national security state when it comes to assassinations, kidnappings, anything that they can relate to protecting national security. So when this decision came out recently from the Supreme Court, it didn't surprise me a bit, because I mean, it would be really strange to say, the national security state's going to be immune from anything they do, but the president's not going to be immune. And so the same immunity that appellate court was giving the national security establishment has now formally been given to the president. And notice that there's nothing in the Constitution at all that talks about immunity, that gives these people immunity for crimes. But that's where we are today, where the president can order the assassination of anyone he wants, kidnapping, assassination, torture, indefinite detention. All he's got to do is say, this is for national security, or this is part of my job as a president of keeping America safe. He is immune from any type of liability for those acts. What do you think about it, Richard?
Well, one way to approach this is that this is not the direction that international law has taken. Whether one agrees or disagrees with the institutional structure or certain reasoning behind it, the fact is there is an international court of justice in The Hague. There's a branch of it that deals with what are considered war crimes or crimes against humanity. There have been individuals from the bloody Yugoslav war of the 1990s who were accused of war crimes or crimes against humanity, genocide, and were arrested and were brought to The Hague, and were put on trial, and some have been sentenced to long terms in prison. The presumption here is that even when there is a political leader in the highest office, he is not immune from a certain notion of a higher law, that is, that the law is impartial and no one is above the law. And that is the attempt for the part of the international community to practice that ideal. I know a lot of conservatives, others don't like these international courts, but I'm talking about the premise, the principle that no man, even a head of state, is above the law if he breaks some legal/ethical notion of conduct that amounts to murder, either assassination or a mass murder. In the United States, as you were pointing out, there is this idea that if a person is involved in the ordering, the participation, or the cover-up of a murder, they have a certain legal liability for which they can be brought to trial, and if found guilty, would be given a term of office, or in some states still have the death penalty. So the idea that the President of the United States is above the law flies in the very notion that there is a higher standard of law and its enforcement that is even above the office that individual is holding. So if a president orders an assassination, if he sets in motion through bribery, clandestine support, for attempts to overthrow a foreign government, and especially if that attempt results either successfully or unsuccessfully in the deaths of innocent people, the idea that that person holding that office could somehow be immune from any legal and moral, certainly responsibility, is abhorrent to notion of the rule of law. I would just add here is that, you know, when they say connected with his responsibilities in office, or with the exact phrasing is, yeah, you could enumerate what are the duties and responsibilities of the President of the United States under the US Constitution, including being the commander-in-chief. But merely because you're the commander-in-chief and you're the head of the executive office doesn't change the fact that there are constraints. That is the very notion of a constitution, that there are things that those holding public office may and may not do. These are the responsibilities of senators and members of the House of Representatives. These are the duties and responsibilities of the chief executive, the President of the United States, and so on. And even if you're holding such a high office, if you act outside of what the constitutional limits of that office permit you to do, you're guilty and should be held accountable for this. Now, the ambiguity, unfortunately, particularly since the Second World War, and either just the tacit allowance of it, or the Supreme Court sort of wavering on these things in various cases, a president basically seems to be able to, like a rubber band, stretch what his duties and responsibilities and legitimate actions under that to allow him to do beyond all recognition of, let's say, 1790 with George Washington, or 1870, or before the Second World War. I mean, when the FBI tried to read the mail of some Washington diplomats, it was found out, I think it was in like 1930 or 31, or was brought to the attention in 1930 or 31 of the Secretary of State. And his response is, a gentleman does not read another gentleman's mail. And they were told to cease and desist doing this. So this basically is establishing an unlimited executive authority that if in some way, shape, or form, he can define it as covered by some elastic responsibility that he has, he can get away literally with murder, whether it be at home or abroad. Then we have a system that is not much different than the one that we find abhorrent in modern day Russia under Vladimir Putin. You speak out against Putin, you're arrested. You bring out embarrassing facts about him or his associates, you're gunned down on a bridge across the Moscow River just outside the Kremlin. You attempt to run against him, you're facing trumped-up charges, and you die in a labor camp, as happened to Navalny not that long ago. And there are no limits on what Vladimir Putin can get away with, and the rationales that he can justify. He is a president that has all power and clearly all immunity. Now, is that what we consider a good and just and proper and ethical political system? If yes, then the Supreme Court's decision is fine. But if it's not, then we have to question the rationale, the basis, and the ethics upon which the justices have made this decision in giving the president unbelievably sweeping powers beyond all restraint.
Yeah, I mean, you bring up a lot of great points, especially on the Constitution. The whole idea behind the Constitution was we, the people, call into existence this government, and it will be a government with limited powers. And there is no power to assassinate people. But if you make the president immune from assassinating people, that's essentially giving him the power that doesn't exist. In fact, if you look at the Fifth Amendment, it specifically says no person shall be deprived of life without due process of law. And due process of law is notice and hearing, that you cannot take a person's life without giving them notice and a trial. And yet, what the Supreme Court has essentially done is nullified that Fifth Amendment by saying, well, if the president does take a life without due process of law, he will be immune from any kind of liability. as long as he can relate it to his official duties. Now, I guess what they're saying is if the president gets angry at a next door neighbor of his sister or whatever for a property line dispute or something like that, and goes and orders the CIA to assassinate that guy, I think they would say, well, he's not immune because it doesn't relate to his official duties. But who makes that determination? I mean, what are the, the prosecutor's going to indict the guy under state law, and they're going to litigate over whether it was his official duties or not. The president's going to say, of course, it was my official duties. I mean, when they just assassinated this guy from Iran, that general, I mean, that's just out and out murder. We're not in war with Iran, and they just ordered his assassination. And Trump says, oh, well, this is protecting national security. So because they can always relate it to national security. And I think it's worth pointing out that if they're given immunity to the president, they're also given immunity to all the subordinates of the president. So that if he orders the military, the CIA to go and assassinate somebody on the grounds of national security, they're going to be immune too. In fact, when I saw what they did in the Schneider case, it occurred to me, as you know, Richard, I've written a lot on the Kennedy assassination. And people say, well, why do you keep doing this? They're all dead, all the people that were involved. And well, it's because the structure of government is still there, the national security state. But I also believe that if they had, let's say, determined some of the CIA and the Pentagon officials that were involved, let's say the Dallas district attorney indicts the head of the CIA, the head of the Joint Chiefs of Staff, and is prosecuting them there in Dallas for murdering Kennedy, I have absolutely no doubts that the Supreme Court would have put a stop to that prosecution on grounds of immunity. Because all they would do is say the same thing they did in the Schneider case, is say, we were protecting national security. Kennedy was a threat to national security. This is our job to protect national security. And the courts, the federal courts, would have said just the same thing they said in the Schneider case. This is a political question. We cannot second guess the national security state on assassinations. That's their job. And those people would have walked because they clearly could have made a case that they took out the president of the United States on grounds of national security, the same way that they were arguing that they should take out the president of Chile on grounds of Chile's national security, as well as the national security of the United States. This is an incredible, incredible decision. I think it was always the case anyway, and the court just formalized it. But to formalize it and say, he can get away with murder, that's an incredible system under which we're living. I guarantee you, the people who put this government together, they were rolling over in their graves because this is not the kind of government.
As I was saying, it has affected and influenced certainly foreign policy since the end of the Second World War. The fact is that the United States government participated in the assassination of Patrice Lumumba in the Congo, and also when they no longer needed Moishambe and Katanga province of the Congo, he was allowed to be done away with. They acquiesced, if not participated, in the overthrow of Ngo Dinh Diem in South Vietnam in what was, I guess, 1962, to replace him because he was now an embarrassment as a Catholic in a country that was predominantly not Christian, and particularly when monks were setting themselves on fire and creating unrest while you're trying to fight the Viet Cong. They have done this numerous times, of which the two I mentioned are just ones that are relatively well known in history, as well as the one you're talking about as the conspiracy of actors in Chile. The fact is that long as the United States follows this type of assertive and aggressive global and interventionist policy under the unofficial title of being policeman of the world, and therefore anything that happens anywhere in any part of the continent is in principle an issue of national security, then that means that there is no end to this, that they can do anything. They can abuse prisoners in a prison in Iraq. They can bomb innocent civilians in drone attacks in Yemen. There's absolutely no end to this. And so as long as this is the foreign policy that the US follows, given the emergent institutional structure that has accompanied it and been the rationale for it, there's going to be no end to this.
Well, and then there were the assassination attempts against Fidel Castro. And when it came out, it was like, oh, well, yeah, that's what we're doing. We're protecting national security. Well, really? By just murdering the head of a foreign nation? I mean, where does that power come from? And that's why I've long argued that the conversion of the government, the federal government, from a limited government republic to a national security state fundamentally altered America for the worse, because it automatically gave the government omnipotent powers. Because when you have a national security state, it comes with omnipotent powers because there's nobody that can stand in the way of those omnipotent powers. I mean, the government is force. I mean, that's what George Washington said. Well, what is the most powerful part of the government, the one with the most force? Well, it's the national security establishment, the Pentagon, the CIA, the NSA. And I think the federal courts realized a long time ago, we can't stand against that kind of force. You know, we send out a U.S. Marshal to arrest the head of the Joint Chiefs of Staff for assassinating somebody. Yeah, with the 82nd Airborne Division protecting him. It ain't going to happen. And I think they realize this, that once you become a national security state, you have automatically become a government that wields omnipotent powers, or at least one branch of the government that wields omnipotent powers. It's and like you mentioned, it's the same with torture. That they go out and torture anybody they want, and there's no criminal liability at all. And you know, they support these ideas of the International Criminal Court for other nations, but not for themselves. They say, oh, we can handle it, we can police ourselves. Well, obviously they can't. Now the question is whether this will affect any of their behavior now that the president knows as a certainty that he's immune for anything he does in his so-called official capacity. It'll be very interesting to see what happens. I mean, another aspect of this is the sanctions and the embargoes that target innocent people with deaths. I mean, when they imposed those sanctions on Iraq, they were killing multitudes of Iraqi children. But you know, they always the courts would always say, well, who can sue for this? Nobody's got standing to sue. That was one of the things. But the other thing was this concept of the political question doctrine, which is ludicrous. But now this immunity thing is all out in the open. They can effectively kill, torture, indefinitely detain. I mean, it essentially says whatever they do at Guantanamo is fine. That there's nothing anybody can do about it. I suppose impeachment is still on the table, but that's a far cry from a criminal prosecution.
I think it's also interesting in the context of what you were just saying, that who are the United States bedfellows in refusing to recognize the International Court of Justice or their branch for the hunting down of people guilty of war crimes? Our partners in not signing that agreement or treaty is Putin's Russia and Xi Jinping's China. Those are among the countries that do not recognize the Hague courts, because the United States position is that we cannot give any higher authority a jurisdiction over the conduct of the president, all the way down to the soldier who has been sent abroad and has been given instructions to do something that these people in The Hague don't like. So basically, every American military, every personnel basically has immunity, unless it is found within the structure itself necessary or convenient. Or an example, to take someone under their command who's done something and prosecute them for it because it serves their interests. The fact is, everyone from the president down to a buck private has immunity.
Yeah, that raises an interesting question in terms of war crimes. Remember, like William Cowley, when he was prosecuted for killing all those women and children in Vietnam. Uh, does this decision now mean that he, if he's, fighting a war that the president has put him in, is immune from any kind of prosecution? It would seem so. They can get away with murder, it seems like to
Yes.
me, under this ruling.
And I'll just mention something that I've mentioned before. The irony of this is that the first code of military conduct was instituted by the United States in the midst of the American Civil War, written by a German-American political scientist named Francis Leiber at the behest of the Lincoln administration. What may the U.S. Army do in wartime, in this case, the Civil War against the South, in terms of treatment of prisoners, of treatment of innocent combatants and their property who are now under captured territory? How are they to treat hospitals, schools, museums, people doing charitable work? And the presumption was that Leiber lays out, and the US government on paper accepted at that time, that these are the restraints, the limits that are not to be gone beyond, that unless you could justify it in the immediate instance and circumstances of battle, or if a person who is in occupied territory could be shown to be acting on behalf of the enemy force, you have to respect them and their property and their life, and not abuse them or impose excessive taxes other than the maintenance of justice in the occupied area that your army now is responsible for. And you are certainly not to interfere with the infrastructure and the institutions of civil society, as long as it is very clear and evident that the participants are not serving the interests of the enemy army. So the fact is, we set up that first code, and we now are one of the greatest violators and breakers and ignorers of it.
Yeah, that's a very interesting point. Not that the North followed those rules when they had Sherman's March to the sea, but at least they talked about it.
Right. That was meant to be the benchmark, the ideal that they were to practice, whether they always preached what they practiced.
Right, right. Yeah, it was not the norm, what Sherman did, and what you're outlining, that was the norm. That was what they had strived for.
Right. And I should just say is that Francis Leiber's code for the Union Army became the basis of all of those Hague conventions of the 1890s and the first decade of the 20th century, establishing the rules of war
That's
that all
amazing.
nations were to practice. And you can go through those Hague documents, the founding documents of those rules, and they all say that they are inspired by Francis Leiber on behalf of the rules of war set up by the Union Army.
That's amazing. Well, that was back even in the midst of the Civil War, where you had horrific violations of civil liberties. It was still, the concept of a limited government republic was still holding within people's minds. All that changes after the 1940s. I mean, that World War II drastically affected people's mindsets. It was like they were shell-shocked. And so it was easy for the statists to say, well, now we've got a new threat, the Cold War, we've got to change our form of government, and everybody rolled over. And here we are with this immunity ruling. Okay, Richard, we're out of time. On that note, we'll wrap things up. Thank you all again for tuning in. If you're new to FFF, come and subscribe to our FFF Daily at fff.org. Check us out for about 34 years of hardcore, principled, no compromise essays on liberty. Richard, it's great to talk to you again. I'll see you next week.
Until next time.